Welcome to our podcast LLM, Legal Layman. Well, I would just like to tell you that we are just students with no professional knowledge on law, but we are just trying to pose our thoughts on the said topic. So let's brief ourselves with the facts of the case. The appellant, Girul Alparak, and respondent number 1, Mahadev Das Maya, decide to come into an agreement for buying and selling of wheat with two other firms. It was mutually decided that only respondent number 1 would be the one who is going to sign the partnership agreement, and the respective shares of profits or loss will be incurred by them both. Well, the transactions resulted in loss, and the whole amount was to be paid by the respondent number 1. When it came to the share of appellant, he simply refused to do so, and the matter went to the court. He came up with the defense that entering into wagering contracts is in itself void under Section 23 of the Indian Contract Act. The trial court rejected his appeal. According to the High Court, at the appellate stage, it was believed that even after entering into wagering contracts, the object of the partnership agreement was not illegal, and they decreed the suit, which presents us to the present appeal in question. Now, what is the issue? The issue was whether entering into wagering transactions for the object of partnership was void under Section 23 of the Indian Contract Act. The decision that Supreme Court held in it was the appeal was dismissed with costs. Thank you. So now that we are done with the case, let's kickstart the discussion with some questions. My first question is to Amrita. What comes under the scope or ambit of law of the Indian Contract Law?
Contract Act is an exhaustive law. So there is always a confusion what comes under the ambit or scope of law under Indian Contract Act 1872, where the rules and regulations issued by competent authority is included under the definition of law under Indian Contract Act. So the Supreme Court in the recent case of Y.T. Girish versus Y. Subbaraju, it was held that any agreement that is forbidden by an order issued by a competent authority is also considered to be forbidden by law as contemplated under Section 23 of Indian Contract Act.
Right. So now my question goes to Aditya. We see horse betting is legal, but what about other wagers? And how does platforms like MPL and Dream 11 come into this?
Alright, so this confusion boils down to the concept of wagering agreements and how the court distinguishes them and game of skill. Alright, so let's simplify this, let's break this down. Wagering agreements are agreements between two parties that bet on the outcome of an event, with the winner taking the pot. The major distinction between this is how the results decided. Is it by a pure chance or by a combination of chance and skill? Wagering agreements are generally illegal in India thanks to various public gambling acts. But if we look at the horse betting scenario, alright, we're essentially betting on the performance of the horse and not just luck.
So where does this line get drawn?
The Supreme Court in the landmark case of Dream 11 made a crucial distinction. The players of Dream 11 essentially create a fantasy team based on real players. The points awarded to them are based on strategical decisions and not just luck. Now, if you look at it from a different viewpoint, while picking out a horse is a passive role because you're just picking a horse and hoping for the best. But while building a fantasy team, right, you have to essentially do a lot of research, do the analysis of the players, and also actively manage the team. All of these are the elements of skill, right? So this is what basically differentiates a game of skill and a game of chance. So via this judgment, the court deemed Dream 11 to be a game of skill and exempted it from wagering contract restrictions.
Actually, Aditya, they are not illegal. There are essentially two types. The law may either forbid from making of an agreement, or it may merely state that if it is made, it won't be enforceable in the courts of law. While the former is illegal, the latter is merely void. Not all void contracts are necessarily illegal, but the courts do sometimes use it interchangeably. It is important to note that all illegal agreements are of void nature, but not all void agreements are illegal. So what is illegal? Something that's expressly forbidden by law is illegal. Now, if we have to talk about unlawful, so is there any real difference between unlawful and illegal? Yes. Unlawful is that the law does not expressly bars it, but the thing is, if it goes against any like morality or public policy, or it defeats the object of law, then it is considered to be unlawful. That is, it is against the original legislative intent. So in this present case of Gerulal Parekh versus Mahadev Das Maya, the case centered around if a collateral involved in a wagering agreement can be retrieved, because the wagering agreement as contested by Gerulal Parekh was seen as void and unlawful. So the courts, drawing from the English common law of gaming acts and the Indian precedents, held that even though wagering agreements per se are void, but the object involved is not unlawful or illegal, and the term forbidden by law is clearly not a synonym of void under section 23 of Indian Contract Act.
So now my question goes to Sai. What is the criteria for deciding what is public policy and what is opposed to public policy?
Justice Barrow called public policy an unruly horse. It is one of those terms that is incapable of a precise definition. In fact, scholars have taken two views on defining what is public policy and what is opposed to public policy. The views are: one, a narrower view which defines public policy under certain heads, like say something that is opposed to the security and integrity of India, or the wider view, which is actually what is practiced in law today. So the wider view, there are two cases that act as a very important precedent in this regard, which are Renusaga Power versus General Electric in 1993 and ONGC versus SAW Pipes in 2003. So these cases lay down 5 principles to decide what is opposed to public policy. The first being that it is against the fundamental policy of India. The second, that it is against the interests of India. The third, that it's against justice and morality. These mainly being the common law principles and principles of natural justice. The fourth, that it is patently illegal. And the fifth, that it is something that shocks the conscience of the court. Now these are the tests that are still used and still relevant today, that the Supreme Court still relies on. When it comes to the Gerulal case, Justice Subbarao noted some very interesting things in the judgment after reviewing both the common law as well as the Indian precedents. He said that although we have adopted the wider definition of what is public policy, we cannot leave it up to the morality of the judge to decide it. He quoted, and I would find this quote very interesting, that the judges can only expound the law and not expand upon it. So this means that public policy should be based mainly on two things. One is what is the common law precedent, and secondly, what is the intention behind the various laws of the country. So that means that the judges cannot impose their morality in the cases, even though they have the freedom to determine it. And I think this is a very important and relevant distinction that was made in this case.
So now my question goes to Vanya. How does this case address the issue of morality of wagering?
Well, this case highlights the restrictiveness of the law when it comes to defining ambiguous concepts like morality by relying on the definitions given in the Hindu law, the common law, and the interpretation of the courts. One contention in this case was that it is the Hindu law that defines what is moral and what is not under Section 23 of the Indian Contract Act, but this was rejected on grounds that the Indian Contract Act is based on common law, and therefore only common law principles should be applied for interpreting the statutes of the Indian Contract Act. Now, at the time of this judgment, upon examination, it was revealed that common law had always refused to deal with the concept of morality outside the ambit of sexual morality. The case mentions that basing any law on the general definition of such a fluid concept would actually defeat the purpose of such a law. Moving on to the interpretation of the courts, there's another restriction, for lack of a better word, that is placed, that is the standards set by the courts. However, in effect, the courts can choose to either confine the definition or expand the definition of morality, but in order to maintain uniformity, the courts rely on the single definition, that is sexual immorality. Therefore, in conclusion, even though law and morality are interdependent, the judges in this case choose to stay confined to the ambit of sexual morality, and they rule that wagering is not immoral. Now, in my opinion, even though the reasoning of the court is correct that immorality is subjective and there is a need to restrict its definition so that it can be used in a practical sense, and therefore wagering is immoral in the eyes of law, the court should actually have dealt with the issue of the morality of wagering when it comes to business agreements. In this case, wagering is limited to the aspect of partnership agreements, and it is based on the rise and fall of prices in the market. there is no express harm that is attached to such forms of wagering, and therefore this case does not actually add anything substantial to the issue of morality of wagering.
Alright, now my question goes to Srijan. We have seen various concepts like forbidden by law, public policy, and morality in this case. Does it depict a contrast between Hindu provisions of law and British common law precedents?
Yes, indeed. See, the case we're looking at right now is from the year 1959. Our country at that time was relatively new. The laws that we follow even to this day have been adopted from the Britain, and this means that the precedents and whatever we follow have been technically taken from the British cases and whatever has been decided in their courts. This creates a slight of a problem that they'll not be as applicable as they are in their context to our context. So, for example, if we look at our case, the interpretation of wagering agreements has been taken from their statutes itself. I would like to highlight a part of the judgment to elucidate this concept to you guys further. If you allow, I'll read it from my judgment. So, the judgment says that Section 30 of the Indian Contract Act is based upon the provision of Section 18 of the Gaming Act of 1845. According to this act, a wager is void and unenforceable, but it is not forbidden by law, and therefore the object of a collateral agreement is not unlawful under Section 23 of the Indian Contract Act. So, according to this Gaming Act, a wager is void and unlawful. It is not completely unenforceable. If there is involved collateral, we can consider it to be enforced. So, but now that India has been an independent country for almost 80 years, we can see the direction of our lawmakers changing. For example, with the new BNS coming into force in the near future, I believe that the focus of the lawmakers has shifted from adopting common law principles which have been set in the Britain to making and codifying our own law that may be applicable in the Indian context. I hope that answers your question.
Sure it does. So that's all for today, guys. We conclude this, and now if you guys are interested in knowing more about this, please consider consulting your legal advisor. Remember, gambling laws can be complex, and this episode is not a substitute for qualified legal advice. Thank you.